We do have breaking news tonight, a deeply divided moment playing out in American history. As we come on the air, President Trump has just been impeached on both Article 1, abuse of power, and on Article 2, obstruction of Congress. The votes down party lines as predicted. And all day long here, we've been watching the short bursts of anger, the closing arguments from both sides. Democrats arguing the evidence was clear, arguing the president used the power of his office for personal and political gain. With this election coming right now, the United States is entering one of the most volatile and dangerous moments in its modern political history, because two unprecedented forces are closing in on Donald Trump at the exact same time. On one side, impeachment articles in the House, 7 of them, are moving forward with charges ranging from obstruction to constitutional violations to outright tyranny. And on the other side, federal judges are openly warning that Trump's repeated defiance of court orders could lead to criminal contempt, meaning jail time, not symbolic penalties, actual incarceration. This isn't speculation. This isn't media hype. This is the convergence of two branches of government tightening pressure around a sitting president simultaneously, each building a legal case that could remove him from power or even confine him to a cell. And this convergence is accelerating. The clock is running. Trump is running out of room to maneuver. Let's break down what's happening on the impeachment side first, because this is enormous in scope. The House has filed impeachment articles, 7 separate counts, each targeting a different aspect of Trump's alleged misconduct. You've got obstruction, you've got the usurpation of Congress's authority, you've got violations of constitutional rights, and you've got the most alarming charge of all, tyranny. Yes, tyranny. The House of Representatives, using its formal constitutional authority, is accusing the President of the United States of attempting to establish tyrannical rule. That's not partisan mudslinging. That's not cable news hyperbole. That is an institutional statement, a legal statement, a historic statement. And while Congress is moving toward impeachment, the judicial branch is escalating its own fight. Federal judges are no longer issuing warnings in subtle language. They're writing opinions that clearly spell out what happens next if Trump keeps ignoring court orders. They're explaining in black and white the legal pathway from Trump's defiance to criminal contempt. And criminal contempt means jail. Judges are making it unmistakably clear they have the authority to find Trump, to sanction him, and if necessary, to incarcerate him. They're not saying this quietly. They are laying out the procedure step by step. They are preparing the ground. So picture the landscape. Congress edging closer to impeachment, judges preparing contempt rulings, and Trump positioned directly in the center as both branches close in. This is not a hypothetical situation. This is happening now. The machinery has started, the gears are turning, and Trump is quickly running out of time to change course. Here's the flashpoint that triggered the latest judicial escalation. Judge James Boasberg issued a very clear injunction. Asylum seekers were not to be deported. He spelled it out in court orders. He made it explicit. No ambiguity. Do not deport these individuals. But the Trump administration went ahead and deported them anyway. They didn't ask for clarification. They didn't delay enforcement. They didn't comply. They defied. They ignored. They violated a direct federal court order. When Boasberg learned what had happened, he didn't treat it as a clerical mistake or bureaucratic misunderstanding. He treated it as defiance, as contempt, and he announced that there was probable cause to hold the administration in criminal contempt. Probable cause is a legal threshold. It means there is enough evidence to believe a crime may have been committed. Boasberg set a deadline. Fix this, reverse the violation, restore compliance, or contempt proceedings will begin. That's not a symbolic threat. That's the judiciary activating enforcement mechanisms. And this violation wasn't an anomaly. It was part of a consistent pattern. Judges across the country have complained that Trump's administration behaves as if court orders are optional, suggestions rather than laws. Analysts found that roughly 1/3 of major rulings against the administration were disregarded, delayed, or directly violated. Trump officials have slow-walked compliance, withheld evidence, reissued blocked policies under new names just to get around federal rulings. Judges are fed up. They're signaling that enough is enough, and they're making it clear. If the administration keeps defying court orders, they will use the full power of contempt, civil or criminal, to enforce the law. Civil contempt could mean massive daily fines, escalating until compliance is achieved. Judges can impose those penalties directly, no prosecutors required. Judges can even order jail time until court orders are obeyed. Criminal contempt is even more severe. Criminal contempt treats the violation as a crime punishable by fines or jail time as punishment, not just to force compliance. Judges can refer criminal contempt to prosecutors. They can initiate proceedings that lead to trials, convictions, and prison sentences. Here's the twist. Trump controls the Justice Department, which means he could theoretically block criminal prosecutions against his own administration, but he cannot stop civil contempt. Judges can impose civil enforcement directly from the bench, completely independent of the Justice Department. Trump cannot intervene. He cannot veto it. He cannot obstruct it. And that is exactly what judges are now pointing to. So imagine the scenario forming: Congress pushing toward impeachment, judges preparing contempt actions, two branches of government closing around a president who cannot stop either process. Trump is being squeezed politically, legally, systemically. This is not just a storm. This is a perfect storm. Let's dig deeper into the impeachment articles so you understand the gravity of the accusations. Representative Sri Thanadar introduced House Resolution 353 on April 28, 2025. That resolution includes 7 articles, each one a separate constitutional indictment. Article 1, obstruction of justice and breach of duty. This accuses Trump of violating his constitutional obligations to uphold the law, respect separation of powers, and fulfill the duties of the presidency. Article 2, usurpation of Congress's appropriations power. Congress alone controls federal spending, yet Trump allegedly spent funds without congressional authorization, an unconstitutional seizure of legislative authority. Article 3, abuse of war and trade powers. This article accuses Trump of ordering military actions without congressional approval, again seizing authority the Constitution grants to Congress. Article 4, violation of First Amendment rights. This charge says Trump retaliated against critics, including judges and investigators, violating protections for free speech and undermining judicial independence. Article 5 in the impeachment resolution targets something that most Americans rarely think about, but is absolutely crucial to how government functions: the creation of lawful offices. The Constitution is crystal clear. Congress decides what positions exist inside the federal government, not the president, not the executive branch. But according to this article, Trump created positions that Congress never authorized. He appointed individuals to roles that were not legally established. In other words, the accusation is that Trump manufactured offices out of thin air to expand his personal authority. That is a direct assault on the separation of powers. Article 6 elevates the stakes even further: bribery and corruption. This charge cuts deeper than policy disputes or political disagreements. It alleges that Trump exploited the power of his office for personal enrichment, that he accepted bribes, that he used the presidency not to serve the nation, but to serve himself. And in the history of impeachment, bribery has always been one of the clearest, sharpest grounds for removal. When a president uses public power as a personal ATM, the Constitution steps in. And then comes Article 7, the most explosive accusation of them all: tyranny. This is not rhetoric. This is not name-calling. This is a constitutional term with constitutional weight. Tyranny is the abuse of government power for oppressive purposes. Tyranny is the attempt to consolidate authority in one individual at the expense of democracy, checks, and balances. The article alleges that Trump's behavior demonstrates a conscious intent to establish such rule, that he is actively undermining the constitutional structure, that he is eroding democratic safeguards. In other words, that he's trying to become a tyrant. Congress is not whispering this. They are stating it formally in an impeachment resolution, invoking the gravest language the founders left behind. These articles aren't just political arguments. They're institutional charges meant for the official record of American history. And there is something else about this impeachment resolution that you need to understand. It was filed as a privileged resolution. That means it bypasses the usual procedural bottlenecks. It doesn't need the blessing of party leadership. It doesn't need permission from a committee. It doesn't need to be placed on some long-term legislative calendar. A privileged resolution forces the House to act. It triggers the countdown to a vote. It puts the question, impeach or not impeach, directly onto the floor. Representative Thanadar filed notice on May 13, 2025, that he intended to bring this resolution forward. That action alone started a legislative clock ticking. Unless leadership finds a way to stall or block it, and even that is not guaranteed, a vote could come at any moment. Tomorrow, next week, next month. But soon, the gears of impeachment are grinding forward, and Trump cannot stop that machinery. But even that political danger pales next to the judicial threat rapidly forming on the other side. Judge James Boasberg's finding of probable cause for criminal contempt sent shockwaves through the legal community. And what's astonishing is how simple the underlying facts are. Boasberg issued an injunction. He ordered the administration not to deport certain asylum seekers. He said it clearly. He said it directly. A federal judge with constitutional authority told the executive branch, do not do this. And the administration did it anyway. That act alone, defying a lawful court order, sets off a constitutional alarm. But when Boasberg examined the evidence, he didn't shrug. He didn't issue a warning. He didn't ask for more explanation. He went straight to the legal threshold for criminal punishment, probable cause. That means he believes there is enough evidence to justify treating this as a potential crime. And Boasberg didn't stop there. He gave the administration a deadline. Fix this, reverse course, comply with the injunction, or the court will begin contempt proceedings. That is a direct line from presidential defiance to potential jail time for those responsible. But here's the real problem for Trump. The deportation incident isn't a one-off mistake. It's part of a much broader pattern, a pattern that judges have been documenting for years. A Washington Post analysis found that Trump officials were accused of ignoring or evading 1/3 of major court rulings against them. Think about that. 1/3 of the time a judge told the administration, you may not do this, they did it anyway. Sometimes they stalled. Sometimes they withheld documents. Sometimes they reissued blocked policies under new names. But the message was the same. The administration acted as if court orders were optional. Judges have noticed. Judges are losing patience. And judges have started laying out the consequences in unmistakable terms. Civil contempt gives judges the power to impose daily fines, massive fines that accumulate until compliance is achieved. They can increase those penalties exponentially. They can target agencies, officials, directors. They can even order jail time until the violation stops. And here's the key. Civil contempt does not require prosecutors. Judges enforce it directly. Criminal contempt is even more severe. It treats the violation as a criminal act punishable by jail or fines. Criminal contempt requires prosecution. But even there, judges can initiate referrals. And while Trump might try to shield his administration from criminal prosecution because he controls the Justice Department, he cannot shield them from civil contempt. Judges do not need the executive branch's cooperation. They do not need Trump's approval. They have their own enforcement power. This is where the noose tightens. Trump can ignore Congress. Trump can fire officials. Trump can stall investigations, but he cannot fire federal judges. He cannot override court fines.